Nairobi.
Now, ODM party leader Raila Odinga has today notified the Court of Appeal that he will be challenging the recent High Court decision that blocked the push for a referendum through the Building Bridges initiative in court. Odinga joins the list of Attorney General Kihara Kariuki, electoral body IEBC, and the BBI secretariat that have filed notices of appeal. Tonight, KTN's Murimi Mwangi highlights some of the key grounds raised by the appeal parties on a day Justice Daniel Musinga was elected president of the Court of Appeal.
It has been 2 weeks since a 5-judge High Court bench slammed the brakes on the Kenyatta and Odinga-led Building Bridges initiative.
Nobody can stop reggae.
And the fight back to revive the BBI reggae is gathering momentum. Odinga, now the latest to notify the Court of Appeal of his intention to challenge the High Court BBI verdict, joining the list that also comprises of Attorney General Kihara Kariuki, the Independent Electoral and Boundaries Commission, and the BBI secretariat that have also filed notices of appeal against the BBI verdict.
The question will be really what is the effect of whatever decision the Court of Appeal will make to the general public. Kenyans, as of today, know that fundamentally there is a legal problem with the document.
In an affidavit sworn on his behalf by his lawyer Mwangi, Odinga wants his appeal heard on a priority basis, as some of the proposed amendments in the BBI bill are intended for implementation before the upcoming August 2022 general election, arguing that the country runs the risk of plunging into a constitutional crisis if the same eventually succeeds, without sufficient time to implement the transitional and consequential measures of the bill. Separately, BBI Secretariat Co-Chair Dennis Waweru, in a supporting affidavit, argues that the High Court stopped a non-existent referendum initiative as the steering committee for implementation of the BBI Task Force report ceased to exist on 30th June, adding that the bench had deliberately ignored evidence that would have proved that they, as the BBI Secretariat, were the promoters of the initiative to amend the Constitution, and not President Kenyatta as alleged by the High Court. In a separate appeal, Attorney General Kihara Kariuki, through Solicitor General Ken Ogeto, accused the High Court of usurping illegal powers, adding that the judge's ruling, it would appear, had decreed that it's imperative for the people, whenever desirous of amending the Constitution, to seek guidance of the court in advance. Electoral body IEBC has also filed a separate appeal, in which it seeks to quash the High Court finding that the agency was not properly constituted to process the BBI referendum push. The IEBC has cited a contrary finding that had been entered by a separate High Court bench in a separate petition on the IEBC quorum issue. These developments came as the Court of Appeal judges elected Justice Daniel Musinga as the appellate court's president. Musinga will now be tasked with constituting the bench to hear both the applications for stay of the High Court decision and subsequent appeals against the decision.
Most likely is going to constitute a bench that is likely to look at the merits and the merits of the appeal, such that it is not likely that external people might interfere.
The Attorney General is yet to file his record of appeal, while Odinga and the BBI Secretariat say they will do so by May 28th. And with the 2022 polls fast approaching, a vicious legal tussle looms at the Court of Appeal. Murimi Mwangi,